All right, this is Karl Gerber on the Karl Gerber Workplace Lawyer Show on Talk Radio 790 KBC. I'm a real workplace lawyer in addition to being a writer, comedian, and Los Angeles historian. And I have actually been representing employees since 1993. I'm licensed in California, Texas, Massachusetts, and Washington, D.C. We're tonight talking about how you get a case because I promised people when the show started 2 years ago that if they listened to all the episodes, they'd be getting an education. And the more shows they listen to, the higher their education would be on employment law. So we've talked about wrongful termination, which is why a lot of people call me at the office at 877-525-0700. But I also want to make clear that there are cases where people have not lost their jobs that we get involved in, and one of them is sexual harassment. When this show started, I was approached by KBC to do a show on sexual harassment. There was a lot of this Me Too stuff going on, seemed big. I'd written some articles that were featured in major New York magazines about the whole Harvey Weinstein thing. That might be how they found me. I don't know. And I told them I thought the show should be about all employment law because sexual harassment's a little bit narrow. It might get a little bit boring. The cases are interesting, but it's just one of the things that is done by an employment lawyer. Sexual harassment involves sex, does it? Well, not really. It doesn't really even have to anymore. In the olden days it did. It needs to be offensive conduct. That's key. If it's not offensive, it's not sexual harassment. And there are some of these cases where, it's just not enough. He was staring at me, and did he say anything? No, I just knew what he meant, or there's one comment or something like that, and it's not enough. So that's where you really need somebody who have done hundreds of sexual harassment cases, tried some like me, to tell you if it's going to work in court or in arbitration as a sexual harassment case. Sexual harassment cases are potentials to be thrown out by a judge before they even get to a jury. That happens because the conduct may be too minimal. And it used to be if there was one comment, that would get the case thrown out. And there's been some amendments, but I don't think I'd take a case if there was one comment or one touching. I just don't think I'd do it. I think that's a lot of work. It's going to subject the client to depositions and a lot for one comment or maybe one touch somewhere, even if it's a touch where it shouldn't be. It might just be too much to involve the legal system in that. You have to pick your battles, and that's something I think a lot of clients don't understand. But sexual harassment is physical touching, obviously, and it doesn't have to just be the breasts or the buttocks. It can be touching people on their face, it can be touching their hands, it can be wanting to make contact, putting yourself in a position where it's likely that you will touch this person. It's a close quarter restaurant area, and so if you stand there, that person is going to rub against the side of you. That might also be an assault. It might also be battery. It might be a sexual battery if a sexual organ is touched, like, the buttocks, genitals, things like that, breasts. So if it's a physical act and it's not intended, that becomes a little bit strange too. Someone is passing by and it really is close quarters and they make contact and it's one time or it's even two times, maybe not something to sue. You have to indicate the conduct is unwelcome, and you could do that by raising your eyebrows. You certainly could do it with words or a text message, but not a text message, "Don't you ever touch my butt again." And then the next text message is, what's your grandmother's recipe for potato salad? What did you say it was? And oh my God, I can't believe your cookies are turning out so well. I've seen that in cases, and that is not really the way that the public expects that you be reacting to someone making your life miserable. A lot of people say, I just wanted to be cool with this person because I had to work with them or they're my supervisor. But the question comes, well, why didn't you say, I don't want to talk to you? Or if you're texting them about cookies, why aren't you texting them about, I don't want to be talked to that way. I don't want to be touched that way. So sexual harassment, unwelcome. We've got that much. We also know that it can be physical or verbal. A lot of cases now involve text messages, and those are good cases because it proves that it happened. The text message doesn't go away. But the ones where someone's claiming there are all these text messages and they don't have any of them are a little bit suspicious. I'd like to talk to you about whether your case is going to work as a sexual harassment case. Call me at 877-525-0700 during normal business hours. That's my office. 877-525-0700 to have a heart-to-heart discussion about whether you really should bring the lawsuit, whether it's the right thing to do, whether I feel it's strong enough that you can win, whether it's a good enough case that I'd take it on a contingency, or maybe I'd refer it to someone else because I don't think it's a quite good enough case for me, but it might be for someone else. Call me at 877-525-0700 if you want to find out if the situation is going to work as a sexual harassment case. I've done probably 500 of them, and I understand how it works, and I'll try to be as nice as possible in talking to you about it. It's a delicate subject matter, and if you give me professional courtesy, I'll give you professional courtesy. I do tell all people calling who are not calling, but people on the internet or people here, that you really need to let me ask the questions. I know what questions that have to be asked, and if you just come on the phone with a long story, it gets very hard to get the right information, and you may be providing a lot of information that isn't really going to get to the point. And I want to make these representations for employees as efficient as possible. If I've been doing this for almost 27 years, the number of cases I've done, and I know I've taken more new client calls in employment law than anyone else alive in this country. I know that, and that's one thing I will guarantee. If I can't use my experience to get you through this faster, then I'm not doing my job. You've got to let me get you through this as painlessly as possible, as quickly as possible, and as good as possible, so you're focused on doing what you need to do on the case, not what you don't need to do. So if you do need to call me about an employment case, 877-525-0700. I'm Karl Gerber. It's the Employment Lawyers Group. You can go to the Karl Gerber with a K channel on YouTube to hear the comedy that's normally on this show. There is some serious legal content on there too. And there's plenty of serious legal content on the firm's websites for the Employment Lawyers Group. It's not hard to find them. We have a lot of websites. The only bad reviews we have are from people who were never our clients and didn't like the fact we rejected them on the phone. We reject a lot of people. We don't take cases that can't be won. It's not right to take cases that can't be won. It's doing a disservice to the client. There might be some low-value settlement in there, but that's not what you're supposed to do as a lawyer. You're supposed to bring cases that you believe have merit. And if they don't have merit and you can't win them, you don't bring them. Short and simple. And you don't subject clients to the unreasonable expectation that all these things are going to happen to them in their case when they're probably going to lose it before it even gets to a jury.